I'm Ben Meiselas from the MeidasTouch Network, and this is a breaking news alert. A disastrous day in court today for Donald Trump and his purported lawyer, John Eastman, in federal court for the Central District of California, where Judge David Carter again found that the crime fraud exception applies to John Eastman's attempt to try to withhold certain documents from the January 6th committee. Here we have a judicial finding by one of the most well-respected federal judges in our judicial system, who found very specifically with very detailed findings of the criminal conduct at play between Donald Trump and John Eastman on January 6th and leading to January 6th. You will recall that Judge David Carter previously made an order ruling that John Eastman's assertions of attorney-client privilege and attorney work product privilege gave way based on the crime fraud exception, and thus John Eastman had to turn over records to the January 6th committee several months ago in his order, which the January 6th committee has talked about repeatedly. Judge David Carter found that this was not simply attorney-client advice, at least with respect to the documents that he ordered be turned over to the January 6th committee, but Judge David Carter previously made the finding that what was really at play here was a coup in search of a legal theory, and that it was more likely than not that Donald Trump and John Eastman engaged in criminal conduct related to January 6th, including obstruction. And here in today's order, we have new and additional very specific findings by Judge David Carter as it relates to this new batch of about 8 documents that had to be turned over to the January 6th committee. Very damaging, explosive documents, which I will talk about shortly. But even more so than ordering that these documents be turned over to the January 6th committee, the judicial finding here against Donald Trump and against John Eastman is devastating, and the Department of Justice must be taking notice. Folks, this is huge. Let me break down Judge David Carter's order for you. So if you look at the first page of the order, the case is styled as John Eastman plaintiff versus Benny Thompson and the Select Committee, because John Eastman brought this lawsuit a long time ago after January 6th to try to stop the January 6th committee from getting his records, arguing that they were all subject to attorney-client privilege. So then it says order a privilege of remaining documents. Page 3, Judge Carter starts right away and says, this court previously conducted 2 reviews to determine whether Dr. Eastman's privilege assertions apply to the records subpoenaed by the Select Committee. In its first order, the court extensively detailed the events of January 6, 2021, and Dr. Eastman and President Trump's actions leading up to that day. The court also held that the President Trump and Dr. Eastman more likely than not committed obstruction of an official proceeding in violation of 18 U.S.C. Section 1512, sub C2, and conspiracy to defraud the United States in violation of 18 U.S.C. Section 371. So that is a judicial finding made. Now, this is not a criminal case. I want to make that very clear. What Judge Carter is ruling on is an evidentiary discovery dispute regarding documents that John Eastman does not want to turn over to the January 6th committee. So based on those findings alone by this judge, the judge does not have the power based on this proceeding to say, Donald Trump, you must go to jail, or John Eastman, go to jail. But here we have a well-respected judicial officer making the finding, as he did previously, that attorney-client privilege did not apply because of the crime fraud exception. I'm going to read through the order a little bit more, which just details the attorney-client privilege, attorney work product privilege, what that is, and then what the crime fraud exception is. Let me just try to explain it to you in layman's terms. So the attorney-client privilege means that communications between a client and their attorney in furtherance of the litigation, assuming the attorney and the client keep that information confidential, and the privilege is held by the client, not the attorney. If the attorney divulges confidential information, they will be disbarred. But in connection with this confidential relationship, the law says that we want those communications to be secret, and in litigation, you can't ask the individual who's getting legal advice, hey, what did you talk to your attorney about? What types of conversations did you have? The law wants to keep those communications and those conversations secret so that people can lean on and rely on advice of their counsel. The attorney work product privilege is work done by the attorney in furtherance of the litigation that they're hired to. So things that you could think about, like what's work product, like notes, legal research, emails about the case that are being sent internally within the law firm about the case, stuff that's related to the representation. And that can't be discovered as well by subpoena or during a litigation. However, there are exceptions to the attorney-client privilege. One exception is if the client doesn't keep the communications confidential. So if the client goes out there and starts talking about the communications, writes a book about it, tells people in public, divulges it to anybody else outside of the attorney-client relationship, that's one way you could waive that privilege, because now the law says, well, you didn't want to keep that secret, so people can now discover it because you're talking about it anyway. Another exception is what's called the crime fraud exception, which is if the lawyer and the client are engaged in criminal conduct, or if the client is going to the lawyer in furtherance of a crime, whether or not the crime actually succeeds or not, that's an exception to the attorney-client privilege, because obviously our law does not want attorneys and clients to engage in crimes and then cover it up by saying attorney-client privilege. So the analysis that this federal judge is doing in this order is to basically say, I have to read these documents that are presented to me, and based on the way I read these emails and these other documents that are found in John Eastman's emails, and remember, these are emails that John Eastman was sending from his Chapman University account. Eastman used to be a law professor at a law school called Chapman University, and he was using that email account to send the emails that are at issue here that he does not want to turn over to the January 6th committee. By the way, you may be asking, well, why is this case going on in California and not in Washington, D.C. or in some other area? Eastman's from New Mexico now. But the reason it's going on in California is because it relates to his Chapman University email accounts. And when Eastman brought the lawsuit, he brought it in the correct jurisdiction, which is the jurisdiction that where the emails were sent from. That's the Central District of California, Southern Division in Orange County, where Judge David Carter sits. So the way this process works is these emails and records, the January 6th committee doesn't get to see it. The process is, at first, the process is that John Eastman claimed these documents to be privileged. The documents are then sent to the judge, Judge David Carter, and Judge David Carter has to do what's called an in-camera review. I-N space camera, C-A-M-E-R-A. And what an in-camera review means is the judge reviews the emails, looks at them, the parties submit legal briefs. John Eastman says these are why these documents are attorney-client privilege. The January 6th committee submits briefs and says, while we haven't seen the records, here are the crimes that we believe are taking place, and we should be entitled to have these records. And ultimately, the judge makes a finding. And here, Judge Carter made the finding after conducting that analysis that the crime fraud exception applied with respect to many of these documents. I mean, specifically, though, there was approximately 536 documents that Judge Carter found. 536 documents or so were either attorney-client privilege or attorney work product privilege. Separately, there were 26 documents where there wasn't a valid privilege claim. So then with respect to the 536 documents that are either attorney work product, or attorney-client privilege, then Judge Carter says, when I read these documents, are there any crime fraud exception issues here that should turn over that should compel John Eastman to turn over those records. And basically what Judge David Carter found is a lot of these documents were John Eastman exploring potential actual legal theories. And while they may be close calls, Judge Carter said, I cannot definitively say that these are crimes, but there were 8 documents and 8 damaging emails and documents, which I will now talk about, where Judge David Carter found that the crime fraud exception applies. So as we go to page 14 now of the order, this is what Judge David Carter says. Well, top of 13, bottom of 14. Having determined that 26 documents are unprotected, meaning that there is no privilege, the court has found that 536, remember I said 536, documents are protected by either work product or attorney-client privilege. The court now considers whether any of the remaining 536 documents should be disclosed under the crime fraud exception. Now the court explains what the crime fraud exception is. The crime fraud exception applies when 1, a client consults an attorney for advice that will serve them in the commission of a fraud or a crime. So here, if Trump consults with Eastman for advice that will serve in the commission of a crime on January 6th. And 2, the communications at issue, meaning the emails and documents that Eastman is claiming to be privileged, the communications are sufficiently related to and were made in furtherance of the crime. It is irrelevant whether the scheme was ultimately successful. An attorney's wrongdoing alone may pierce the privilege regardless of the client's awareness or innocence. The exception, which both extinguishes the attorney-client privilege and work product doctrine, applies only to documents and communications that were themselves in furtherance of the illegal or fraudulent conduct. So it's a 2-part analysis. 1, was there a crime being committed? And 2, were these documents at issue, though, in furtherance of that crime? And then Judge David Carter says, as to the first prong of the crime fraud exception, the court has previously determined that President Trump was more likely than not to have engaged in or planned in the obstruction of an official proceeding in violation of 18 U.S.C. Section 1512 C2 and a conspiracy to defraud the United States in violation of 18 U.S.C. 371 when he sought the advice of Dr. Eastman. So prong 1 satisfied. Now, Judge David Carter says the court now turns to the second prong of the exception to determine whether any of the 536 emails were now sufficiently related and made in furtherance of the obstruction and conspiracy crimes Trump committed. In the last batch of documents, the court finds that the crime fraud exception applies to 8 communications. So now the court's saying, I've done this analysis. Prong 1, Trump committed crimes. Prong 2, I have found that at least 8 of these documents that I'm now reviewing show that he was engaged in furtherance of those crimes in these specific documents that are before me. Now the court says, well, what are those documents? And this is where it gets really damaging. I mean, if it wasn't already incredibly damaging. Emails related to and in furtherance of delaying or disrupting the January 6th congressional proceedings. Emails related to and in furtherance of delaying or disrupting the January 6th congressional proceedings. The court's prior orders address several email threads related to ongoing or prospective litigation in key battleground states. In the current review, the court finds 18 similar documents that present close calls. And here the court says, look, there are close calls. Some of these look very criminal, but for these group, well, I'll just say the crime fraud exception does not apply. But there are 4 documents, however, in which Dr. Eastman and other attorneys suggest, irrespective of the merits, that the primary goal of filing is to delay or otherwise disrupt the January 6th vote. In one email, for example, President Trump's attorneys state that, quote, merely having the case pending in the Supreme Court not ruled on might be enough to delay consideration of Georgia. Bombshell. merely having the case pending. So what Judge Carter's saying is these emails show that they knew that their entire litigation strategy was complete BS, because here we have emails now of them, which the January 6th committee is going to get. Now, this is what we call a smoking gun. Merely having this case pending in the Supreme Court not ruled on might be enough to delay consideration of Georgia. The judge goes on to say, this email, read in context with other documents in this review, make clear that President Trump filed certain lawsuits not to obtain legal relief, but to disrupt or delay the January 6th congressional proceedings through the courts. The court finds that these 4 documents are sufficiently related to and in furtherance of the obstruction crime. Think about that finding by a federal judge right there. That Trump was not actually seeking legitimate legal relief, but simply to disrupt or delay the January 6th congressional proceedings through the courts, and that these documents are sufficiently related to the obstruction crime. First batch of documents, crime fraud exception applies. January 6th committee now has these records, and you now have the records too, because you heard what they say. The next batch of records, 2. This is on page 16 of the order. Emails related to and in furtherance of the conspiracy to defraud. 4 emails demonstrate an effort by President Trump and his attorneys to press false claims in federal court for the purpose of delaying the January 6th vote. The evidence confirms that this effort was undertaken in at least one lawsuit filed in Georgia. And so this is a bombshell, too, because the judge explains. On December 4th, 2020, President Trump and his attorneys alleged in a Georgia state court action that Fulton County improperly counted the number of votes, including 10,315 deceased people, 2,560 felons, and 2,423 unregistered voters. President Trump and his attorneys then decided to contest the state court proceeding in federal court as well. But then here's the email that we got on December 30th, 2020. Dr. Eastman relayed concerns from Trump about including specific numbers in the paragraph dealing with felons, deceased, moved, etc. The attorneys continued to discuss the president's resistance to signing when specific numbers were included. So here we have actual email evidence, which we knew to be the case, but directly linking Donald Trump that he knew all of these numbers that they were putting in complaints were completely false numbers. The court goes on to say, as Dr. Eastman explained the next day, although the president signed a verification for the state court filing back on December 1st, he has since been made aware that some of the allegations and evidence proffered by the experts has been inaccurate. For him to sign a new verification with that knowledge and incorporation by reference would not be accurate. Boom. Boom. Dr. Eastman's email says that. The January 6th committee has that. You now have it. The email from Trump's lawyer saying Trump signed a verification that was wrong and that was false. We've now been aware that those allegations are false. He should not sign more verifications stating these false numbers. But the court goes on to say, President Trump and his attorneys ultimately filed the complaint with the same inaccurate numbers without rectifying, clarifying, or otherwise changing them. President Trump, moreover, signed a verification swearing under oath that the incorporated inaccurate numbers are true and correct. The emails show that President Trump knew that these specific numbers of voter fraud were wrong, but continued to tout those numbers both in court and to the public. The court finds that these emails are sufficiently related to and in furtherance of a conspiracy to defraud the United States. And the court orders that those emails, again, we just talked about what those emails say, be turned over to the January 6th committee and are now made public. We now have absolute evidence, a finding by a federal judge that Donald Trump committed penalty of perjury, that he lied under penalty of perjury. We have absolute evidence from a federal judge stating that. And that's big, big, big news from that finding. The crime fraud exception applies, obstruction, conspiracy to defraud the United States. These are critical findings. And for the reasons explained above, the court orders Dr. Eastman to disclose those other documents, which there wasn't a privilege, and then these 8 additional documents to the House Select Committee by 2 p.m. October 28th, 2022. The good news is we mostly know what they say right now. So will there be an additional January 6th committee hearing with these records? Will the January 6th committee make these records public through some other forum, perhaps sharing them on social media? We will see. Signed, Judge David Carter. This is big. This is big. And this finding by the federal court, this 18-page ruling, is unimpeachable. We will put a copy of this ruling in the links below, but make sure you share this video with everyone you know. It was critical that I brought you through all those steps because there's a lot of disinformation out there. You need to know what the law is. You need to know specifically what this judge held. You need to know the import of it, how it relates to everything. And you need to know the specific findings. But for all of your, if you still have MAGA friends or whatever, or know people who are MAGA, hard to be friends with them. But if you know someone, here you have an email from Dr. Eastman explaining that they were aware these numbers were false. Bombshell. Needle in the haystack of information. Bingo. That is exactly why the January 6th stick-to-itiveness. There were all these other documents that didn't matter or were irrelevant, these 500 other documents, but that was the precise one that the January 6th committee was looking for. They got. I can't stress enough how big that is. Do me a favor, hit the subscribe button right now. We are on our way to 1 million subscribers with your support. Hit the subscribe and share this video. That was the point I was making before. And if you know people who are, who buy the BS and the echo chamber bullshit, send them this, video. Send them this order. I went through the order. This is what the order says. You have Trump's own lawyer saying that they knew it was false. They knew what they were saying was lies, and Trump signed a false verification anyway. In Trump's lawyer's own words, that we now have those records for. Hit the subscribe as we head to 1 million subscribers. And in addition to subscribing, if you want to help grow this independent media platform, we are not sponsored by, or we don't take no outside investors at all. If you want to help grow this network, go to patreon.com/MeidasTouch, patreon.com/MeidasTouch. There's a number of exclusive membership tiers. We're fueled by democracy and powered by you. You could become an honorary producer of our podcast, get postcards from my brothers and I. You could get exclusive podcast content and more. Check it all out at Patreon, patreon.com/MeidasTouch. I always get asked, how can we help grow this? Ben, what can I do? No matter where you are in the world, that's what you can do to help. Go to Patreon, patreon.com/MeidasTouch. Until next time, I'm Ben Meiselas.
At MeidasTouch, we are unapologetically pro-democracy, and we demand justice and accountability. That's why we're spreading our message to Convict 45. That's right, gear up right now with your Convict 45 tees and pins at store.MeidasTouch.com. That's store.MeidasTouch.com.